We've stood at the front lines of law, leadership, and public service. Attorney Karen Jimeno, sharp, steady, a lawyer, an educator, turns complex issues into clear insight. Attorney Mike Toledo, seasoned, fearless, a strategist and communicator whose voice has shaped public understanding of law and governance. Together, they make the law accessible, connecting principles with real-life questions, confronting the issues that define our nation. This is Abogado.
Good evening and welcome to Abogado, where we examine the law and the standards expected of those who practice it. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight, recent developments raise difficult questions about conduct, accountability, and the limits of personal expression. Here is tonight's issue.
Lawyers are trained to speak with courage, challenge authority, and defend even unpopular causes. But does the lawyer's oath follow them beyond the courtroom? The Supreme Court says it does, requiring dignity in both professional and personal conduct, even online. Critics warn that disciplining harsh speech may chill advocacy, fair criticism, and free expression. And when the court initiates, hears, and decides a case on its own, questions of fairness also arise. Tonight, we ask, when does speaking out cross the line for lawyers?
With us tonight is Attorney Domingo Cayosa, former National President of the Integrated Bar of the Philippines, widely recognized for his constitutional law commentary and his public-facing analysis on various legal issues. Good evening, Attorney Cayosa, and thank you for being here.
Good evening, Karen. Good evening, Mike. Good to be back.
Attorney Cayosa, let's start with the first question. Almost everyone shares their opinions online, lalo na't merong social media. It's so easy to comment or post your opinion. But why does the law hold lawyers to a higher standard of propriety, even in their personal dealings? And how far does that duty reach?
But first, because lawyers were supposed to be officers of the court. So we hold not only a professional position, but public interest is involved. We are quasi-public officers, especially for litigation lawyers. Secondly, the reality is that lawyers run the justice system of this country. And justice is a public good, public interest. So with the judges are lawyers, the fiscals are lawyers, the defense counsels, prosecution counsels are lawyers. So we run the justice. So it's very important that the trust and confidence of the people in the justice system is maintained. And that is why the conduct of every lawyer in this country should be up to the level of the expectations of our people. So those are the fundamental reasons why the Supreme Court or even the Integrated Bar of the Philippines and every lawyer, it's our business to see to it that all of us conduct ourselves properly.
Attorney Cayosa, definitely being former president of the IBP partner, you speak from experience, not only in terms of theory, but in practice. That is why I'm asking this next question. In one case, a profane post was made in a personal capacity in defense of a family member, resulted in a one-year suspension. The IBP had only recommended, if I'm not mistaken, only a fine and reprimand. But the Supreme Court apparently imposed a much heavier penalty. So, in your view, Paniero, what principle justified such upgrading of the penalty?
Well, we don't know why, but as you say, as IBP National President, one of our most difficult tasks in the National Board, and I as and any IBP president, is to investigate our fellow lawyers. And during my time, every month, we rule on at least 30 to 50 cases That's how,
Napakarami.
napakarami.
So maraming na-file na complaint.
Marami
And I guess,
talaga.
partner, to provide context, this is public knowledge naman eh. What you're referring to is the complaint against Attorney Just Falsis, right? I think he was trying to defend his sibling dun sa issue with Chris Aquino. And this was the recent one-year suspension that was imposed. So, but as you were saying, Attorney Cayosa, marami talaga kayong
Marami talaga.
complaints na natatanggap.
I'm also, and the statistics will bear me out. This is not my opinion. I look at the statistics. 80% of cases against lawyers are really harassment cases. Natalo lang sa politika, natalo lang sa kaso, aggrieved neighbor, na wala naman talagang sufficient basis, kinakasuhan siya. Why is that? Because once a lawyer is accused or responded in disbarment case, yung kabilang panig, ina-announce nila eh. But
Para
we
mapaya.
lawyers, we cannot talk about it. It's confidential.
They're really out to also embarrass you.
Correct.
In fact, if I may share to everyone, I remember there was an attempt to also disbar a long time ago.
So there was also a disbarment case filed against you?
Because I won a case, and apparently the opponent was not very happy about how that happened. In all the fora that he brought the case to, fortunately, I won. So they just filed for purpose of harassment, but of course the IBP and the Bar and Judicial Council of the Supreme Court can already see from the very beginning that this was just a form of harassment.
Yeah, so you can tell if it's a harassment or if it's a legitimate complaint.
Yes, of course, because you have commissioners authorized by the rules and by the leadership of IBP to investigate, and these are impartial co-lawyers. And you could see, and many of these cases, they just file and they will not pursue it.
Yes.
Unfortunately, under the old rules, we were not allowed to dismiss it outright. Pero eventually, that was amended. Na kung wala naman talagang basehan, you dismiss it na kasi hindi naman talaga magpo-prosper. But not that we're avoiding any responsibility, not that we're lowering the threshold of conduct, but that's the statistics. But even the 20% also na may kaso talaga, that's masyado marami rin yan. In the sense na meron talagang kasalanan yung abogado. But then, going back to your question, bakit IBP mababa lang
and then the Supreme Court, wanted to go back into that. Why did the Supreme Court increase the penalty to much heavier penalty?
One, that's really the call of the Supreme Court. Because even if it's the IBP through its commissioners investigating the case, they hear the evidence. They cross-examine and they observe the demeanor. And, both sides are given a chance. So, underground sila, they know. So, they can temper. And, the members of the Board of Governors and the leadership of IB are practicing lawyers. So, they know the reality on the ground. So, they also temper their recommended penalties based on what is happening on the ground. Unfortunately, in the Supreme Court, they review it, but they don't really, interview or, cross-examine or listen to the testimonies anymore. It's just based. So that's their discretion, of course. So it's much easier for them to be strict with lawyers. Of course, that's their call. But 90% of recommendation of the IBP National Board, usually that's adopted by the Supreme Court. In this particular case, of course, you're surprised bakit mas
harsh.
Siguro, I'm not privy to what the reasoning is. And usually in their final decision, which is public already, they don't really explain. But sometimes what is happening in society at that particular moment might have an influence. Especially nowadays, with a lot of cases where lawyers publicly using social media, and especially so in our new Code of Professional Responsibility and Accountability, there's a specific section about online utterances and social media use. So siguro yun lang to drive home the point. But unfortunately for the respondent, tinaasan nga nila. So yung iba taas kilay, but unfortunately that's Supreme Court. Final yun.
Yeah. And what do you think would be a good approach to balance free speech, freedom of expression, with using dignified language online? Because in this case, the court also rejected the free speech defense. And they said that lawyers must use dignified language even online. So what would be a good approach for lawyers? I know that when it comes to the internet, a lot of people get to speak their minds, na no holds barred, but would you say that for lawyers, we're really subject to a different standard?
I think so. Well, if you don't want to be shackled by these ethical and professional standards, don't be a lawyer. but because, with more responsibility and the nature of our profession, we are involved in public interest. That's expected to be a higher level of conduct for us. Similar to public officials, we expect a higher level of conduct for them. So, but personally, I think all of these rules about conduct vis-a-vis freedom of expression, since it in a way restricts your basic human rights, then dapat strictly construed. But we have to realize also and accept the fact that disbarment cases or complaints against lawyers, these are a class of its own also, of their own. Kagaya din ng impeachment. Sui generis.
This is not like libel.
Yes,
no?
it's not criminal, it's not civil, it's not administrative. And if you read the totality of the Code of Professional Responsibility and Accountability, and even the earlier Code of Ethics and jurisprudence over so many years, halos lahat pwede. So, it is now for the lawyer to impose upon himself that caution and that higher level of conduct. You can express yourself freely, you can disagree. Just make sure you don't, you do it properly. There's
Walang
a way.
mga profanity.
Wala namang content dito. They don't
Yes.
edit or they don't prohibit content.
So in
It's
other
how
words,
you do it.
Attorney Cayosa, what you're saying is, well, the Bill of Rights under Article 3 of our Constitution clearly gives the right of freedom of expression, the right of free speech, and of course of the media. What you're saying is, if you're a lawyer, while you're of course entitled to the same air of freedom granted by the Bill of Rights to express yourself, being a lawyer puts upon you a higher level. Meaning to say, you cannot be just like the other people in that sense. You cannot go online and say, "Wait, I'm not talking as a lawyer now. I'm talking as a private person," or something like that. In other words, once a lawyer, always a lawyer. It will have to. You will be guided by the Code of Ethics.
And like what Attorney Cayosa said, kung ayaw mong makashackle, huwag ka na lang mag-abogado. Because you can expect the same leniency. Yeah.
Correct.
And let me also point out, like you say, for lawyers, whether it is your professional conduct, you say it out of your professional function or public function, or whether you do it in public or in private, pareho yung ethical standard natin eh. That's the big difference. For others, pag public official, wala sila masyadong pakialam sa private life mo. But for lawyers, whether it is private, official, professional or not, you are held to a much higher degree or level of
Much higher standard pala ang ating partner. We have to be very, very
Yeah,
careful.
no, that's why
when we
merong
post
mga
online.
na-filean din nga ng mga
Exactly.
disbarment
Yes.
cases over their personal relationships,
Yes,
right?
correct.
Oo.
Now, in 2023, Attorney Cayosa, the court unanimously disbarred a lawyer over a profanity-laden viral video where he was uttering misogynistic, sexist, and abusive language. What factors distinguish speech constituting ordinary misconduct from speech serious enough to amount to gross misconduct and warrant the penalty of disbarment?
Yeah, this is with Attorney Larry Gadon naman, right? And I remember that. So I'm naming it
provides the commentary.
para maalala naman ng mga, para ma-relate ng tao. Like, sino nga ba yung na-penalize? So para lang they can understand the context more.
But again, you can express yourself, but when you start violating the law, and mind you, there are laws about those kinds of remarks, no? Safe Spaces Act and many others. And even our Code of Professional Ethics and Responsibility and Accountability covers that. Diba? Yung safe space, bawal yung harassment, bawal yung mga ganyan no, na komento. So, on point na yon. But I think, again, itong nangyari sa kanya, in context, records would bear us out. There are many other cases na sanction na siya eh. So paulit-ulit lang. The other one, of course, is to my mind, degree of publicity. It was out there in the open. So those are why it was unanimous because everybody saw it. But I could understand also, Attorney Gadon, this is the more challenging part for the Supreme Court. Sabi niya, sana all. Sana all. Because there are also other lawyers, equally notorious or equally famous or public figures, doing these things, but parang
But then
wala.
what's the language? In your
Yeah.
opinion, yung language ba ng ibang lawyers, ganun din ka-profane, ganun din ka-excessive to warrant the same penalty as disbarment that Attorney Gadon?
I think so. Sometimes it's even worse than that. But then,
Okay.
again, like, how come they're not being held to account? Of course, sometimes walang nagko-complain. But then, if you look at the rules, the Supreme Court has the power to motu proprio investigate. So, but it's not happening. And that's why, to my mind, that has to be addressed because nako-confuse ang taong bayan eh. Na bakit ito kaagad? Ito hindi naman. So, yun yung selective justice, yung hindi consistent ng application. If that happens, then the purpose of all of these rules, because it's not really to punish, it's to deter and to keep everyone up to that high standard. Yun, it's really not to punish. But if it is not equally applied, or if the penalty or the sanction comes very late in the day, so baka nanonormalize. So it defeats the purpose. So that's another aspect that we can look into.
Now, Attorney Cayosa, where does the court draw the line between sanctionable language and forceful but legitimate criticism of judges, courts, and public officials? Because to prohibit a lawyer from actually criticizing sometimes decision of judges or justices does not only violates his freedom of expression, but it also violates his being an officer of the court, to be able to call out the court for any perhaps wrongdoing, misunderstanding, or misrepresentation, or misapplication of the law. So where do you now draw the line between a legitimate criticism and otherwise?
I think the line here is how you do it. Because definitely, even our profession, we are encouraged to criticize what is wrong in what's happening in our country or even in the court or what we feel is a wrong decision. There's nothing wrong with criticizing that. But it's how you do it. Because you can actually criticize without being unethical, without being rude, without being contemptuous. So I think it's the way, it's the how that is sanctioned, not the why or what, because it is certainly part of our duties. You're correct there, Mike. It's part of the duty of a lawyer to point out something that is wrong, even if that may be the decision of the Supreme Court, as long as you do it within the bounds of decency and proper conduct.
And Attorney Cayosa, how much are other circumstances like anger and just responding to another criticism, meaning merong nag-instigate, how much of those could mitigate the liability or the sanction against the lawyer?
Well, possibly it will mitigate in the sense that the penalty might be lowered, but it doesn't excuse the conduct. Because, like, unfortunately, this is not a criminal case. In criminal law, they libel you, you can libel back. You know, in a brawl, they hit you, you can hit back because it's a brawl, and then that's a justifying circumstance. But this is not criminal law. This is ethics. So, again, lawyers are put at a higher level of conduct that, you know, you can respond to a wrong done to you properly and still maintain the ethics. So, it is not a defense. It is not a defense because this is not a criminal case. It's your ethics, and that kind of reasoning does not apply, unfortunately. Even, and it's called for a lawyer because we should be trained by that. Because in trial, as we see in many public trials, it's really antagonistic. But you keep your cool. You know, you don't blow up yourself in front of everyone, because let's focus on the issues. Let's focus on the facts. Let's focus on the law, and, you know, let your emotions die down. take control of your emotions.
Kailangan mahaba ang pasensya kung magiging abogado. Thank
At
you
professional
so much.
ka. Dapat.
Yeah, salamat, Attorney Cayosa. When we return, the Supreme Court's power to start these cases on its own, how it works, and whether a power that complete should carry built-in limits. Don't go anywhere. This is Abogado.
Welcome back and thanks for joining us. You're still watching Abogado. Now, before the break, we traced the line between the lawyer's free expression and professional misconduct. Now we look at who polices that line and how. Still with us is Attorney Domingo Cayosa. Now, Panyero, the Supreme Court, as we all know, may initiate disciplinary proceedings against a lawyer. And you actually mentioned this a bit earlier, motu proprio, or on its own.
Sure.
Even without a complainant. Now, once the court initiates a case, what process follows and what opportunities does the respondent have, the respondent lawyer in this case, have to answer the allegations and present a defense?
Well, it's correct. They do that, but sparingly. It's part of their power, a prerogative under the Constitution and under the rules of court. So, but they do that sparingly. The process is, whether it's a Supreme Court motu proprio or the IBP or upon a written complaint, the process really is you're asked to explain. So you're given a chance to defend yourself. So more often than not, the Supreme Court really doesn't have the time to investigate. They can't even, attend to all the cases that are pending before them. They find it difficult. They're swamped with cases. Nadidelay yung iba. So usually they assign that to the IBP. But then how fast they assign that to the IBP for investigation, hindi rin consistent. Walang time limits. This is the limitation and the ill in the rules. Walang time limit. So depende, maghintay ka. So everybody is given a chance to explain themselves. And once the recommendation or the decision by the Supreme Court itself, they can do the investigation if they want to. So once they do that, just like any ruling, they'll have to say, these are the facts and this is the basis for our ruling. That's part of due process. Everybody's entitled to that. And then the aggrieved party can ask for a motion for reconsideration. And if he's found guilty nevertheless, there's a rule that now allows them to seek for judicial clemency. So if they can show that they accept the responsibility, they have reformed, they can become good lawyers still, in many other circumstances, and the Supreme Court is convinced, even if you're disbarred, they can allow you again to practice.
Okay.
So meron ng
So may
ganon.
pag-asa pa pala. Pag disbarred, it doesn't necessarily mean forever ka nang hindi magiging abogado ulit. There
Yes.
might be an opportunity for clemency.
Yes, because also the general trend now is we're moving away from the punitive concept of justice to reformative or transformative justice. So that's why ngayon sa rules, malinaw, meron na yung process for judicial claim. But that's not immediate. You have to really
Meron
show.
na ba? Meron na bang nangyari?
Nakakuha ng
Meron
clemency.
na.
Nakakuha ng clemency.
Marami na rin.
Marami na.
Siguro hindi natin napapansin.
Oo.
Because,
Sa
it's not
Ang dami
publicized.
ng napatawad. Pinagbigyan.
And, Attorney Cayosa, because the court has the power to initiate the proceedings and then to met out the penalty, what safeguards do we have to ensure that there is both fairness and objectivity and, of course, impartiality as well?
Well, one, of course, is the due process nga. Any respondent is given a chance to explain himself. And then any finding of the Supreme Court of guilt or innocence must be based on facts and evidence. Hindi pwedeng tansya lang nila yan. And then, of course, the requirement is that when they make a final decision, it's part of the records of the Supreme Court. So it's made public. Before that, it's all confidential. So at least walang prejudgment, walang bashing. But once it is decided with finality, it becomes part of the record of the case. So Supreme Court is also held accountable to the profession and to everybody, because everybody can read the decision. So those are some of the procedural and fundamental safeguards to make sure this is not weaponized, this is not abused. No? But ang mas ticklish dito is feeling nung iba, bakit ako lang? So, it helps now that under the Code of Professional Responsibility and Accountability, may mga degrees ng mga 3 levels of grievousness or seriousness of your offense plus the penalty. So, at least, hindi na yung napakalaki ng range. So, meron ng that helps also calibrate the penalty imposed. So, yun ang ano lang we need to improve lang is when is the time that the Supreme Court should really exercise the motu proprio? To my mind, it should be based on the publicity. Because kung public knowledge yan, damay tayong lahat kung walang mangyayari. So publicity, public interest, and the power of the person who is doing that,
And
of the
by
lawyer.
that, you mean, kunwari, may lawyer na maraming followers,
course.
tapos post ng post, and then it's widespread that would satisfy both the publicity and the power of the
Yes.
person that
Halimbawa,
posted.
kayong dalawa, your public figures, your anchors of a show, kilala kayo lahat, and you utter these unsavory remarks or all of these libelous things, or you claim things that are dishonest. So you should be held higher level account. Or for example, you're a high
Saka malaking
government official.
ano to, most likely pwedeng mag-motu proprio investigation.
You know why?
Yeah.
Because the objective really is to protect public interest,
Yes.
public
Yes.
perception,
Yes.
the integrity of the profession, integrity of the administration of justice. So pag ganyan, dapat ang Supreme Court huwag na maghintay ng
Yes.
Na
ng
may
complaint.
mag-file pa. oo.
This is an example, partner, when you would want the warm embrace of anonymity. Because being unknown would have its distinct advantages.
Oo nga, tama.
Now, Atty. Cayosa, when the respondent, let's say in this case, is also a lawmaker, member of Congress or a senator, and the question remarks were made in Congress, and we know that supposedly remarks made in Congress you cannot be held liable for if they're in session, right? How does the speech and debate privilege interact with the lawyer's continuing obligations under the bar, under the Code of Conduct?
Well, that's a gray area. As we all know, if it's in Congress to promote healthy debate, freedom and independence of the lawmakers, they're allowed so much leeway. So that's the jurisprudence, that's the rule. But then again, ethics, as we say, disbarment cases, disciplinary case for lawyers, is a class of its own. So it's not the substance of what you say, but how you say it. So again, we don't have too many examples of that. I cannot think of one four-square example of that. But dun mo din makikita na this is not exactly applicable. Yung immunity from suit for whatever you deliver in the halls of Congress would apply. Kasi ethics ito eh. So, maaring ganon. But I think even the congressmen and the senators, they have that in their rules. You are free to say anything, but you have to maintain the level of decorum required by their own respective rules.
And they have their own ethics committee as well, right?
Correct.
In the House of Representatives
Yes,
or
you
in
cannot
Senate.
also do that. You cannot
penalize
lie
them.
outrightly. You cannot, you cannot libel your fellow congressman. Ganon din sa abogado. So, if you're a public official or a congressman or a senator, and you're a lawyer at the same time, medyo mas mataas din.
And hindi necessarily protected speech. If you're a lawyer who's also a congressman, for example, and you say things that are libelous during a privileged speech, maaari ka pa ring masanction as a lawyer sa
Yes,
Supreme
I think
Court.
so. That's my thinking, and more so because you're a public official. You have the privilege of speaking in the halls of Congress. You have immunity from criminal prosecution or civil claims, but you have to observe your ethics as a lawyer.
Thus far, we have not heard of any.
Yeah.
But it doesn't mean it's not possible, as you pointed out, partner, and as you further clarified. So I guess that's a sort of a, not a warning, but just for people to know.
An awareness
An
for
awareness
public officials,
that,
no? That
you can be
makalusot ka
held
man sa
liable.
Congress or
Yes.
being sued for libel, pwede pa rin
if you're a lawyer,
pumunta sa
especially.
Supreme Court yung iba. Kung ikaw yung victim ng libelous statements of a lawmaker, for example, pwede kang pumunta sa Supreme Court to complain. But So speaking of that, our vice president is also a lawyer. So theoretical question, because she's already facing impeachment over
Yes.
the threats that she made to the president, the first lady, and former Speaker Romualdez. So kung ganon, pwede rin palang ma-filean dapat dati si Vice President Sara as a lawyer sa Supreme Court for the manner of speech she had during that evening when she had a press conference, and she made utterances against, like, threats that were made against the president, the first lady, and former Speaker Romualdez.
But I think so. It's the same reasoning. You're not exempted because you're the vice president or the congressman. And the pendency of an impeachment case does not prevent any ethics case against any lawyer, whoever you may be. You may be the president, the vice president, or congressman, or senator, or anybody else, from proceeding. Why? Because it's a totally different case. You have a totally different authority that will decide on the merits of your case. In this case, it's a Supreme Court. Hindi naman impeachment case ito. Pangalawa, as I said, and this is not in the rules, but I think it should be the background of everything. The higher your position, the more powerful you are, the more public you are, the more careful you should be. The higher level of integrity and good conduct you should have. Why? Because, as I said, our Code of Professional Responsibility and Accountability and ethics, it's not about punishment. It's not about making you liable. It's about upholding a certain level of conduct. It's protecting the public interest. It's protecting the institutions and the profession that you represent.
Okay, so
Just a follow-through
ako
partner
rin
to
eh.
what you
Sige,
mentioned.
let's see kung pareho tayo ng
Because
follow-through. I have a follow-up question
because
also.
you raised already
Yeah.
the vice president, the ongoing impeachment case. We all know naman that even, assuming for the sake of argument, whether she is convicted by the Senate or not, or acquitted by the Senate, it does not in any way forestall or stop the filing of whatever criminal, civil, administrative cases, because impeachment is a totally different thing as compared to these cases. Am I correct?
Correct.
And following your argument again, and following the discussions, it also means that because of such utterances, the Supreme Court can, motu proprio, on its own, conduct their own investigation as to whether or not she can be held liable as well for those statements. Is that a correct statement?
I think so, yes. That's very clear. And as I said, it becomes more compelling to a degree because it's made publicly and because she's a powerful public official. So that's why people wonder, what's happening? How come? I don't know. I think somebody filed a disbarment case against her for that. I'm not too sure about that. But,
okay.
But,
But
we need to know. We need to have some transparency here, what has happened to that.
To that case.
But
But,
it's not even that. Like, yung sinuntok niya na clerk of court. Official yun ng korte. So, it's not clear to us. We don't know. Ano na bang nangyari doon? So, these are all the things that come to play when we hold other lawyers accountable. But then, yun ang palaging sinasabi, sana all, but kami lang.
Attorney Cayosa, sorry, last question before we go on a commercial break while
Go,
it's still related to this topic. So, let's say if you have a president who's also a lawyer and they also utter mga profane or libelous statements, because we all know that under our Constitution, may immunity from suit yung presidente. Would the president be immune from an ethical complaint as a lawyer that is made before the Supreme Court?
I think if it comes to the president, there will be a difference. I think he will be immune while he is in
president.
office. Because
So it's really
immunity,
all-encompassing.
Yes,
like
because,
hindi lang for criminal and civil cases, it's also even ethical cases.
yes, because the immunity from suit is not really absolute. After you're done with your presidency, you should be held accountable. But the practicality of that is so that the chief executive, the commander-in-chief, our political leader will not be hampered and harassed by so many cases
While in office.
Yun lang naman eh. It's a practical reason. So I think that should also be applicable to
Okay,
him.
so nandun pala yung distinction. Thank you so much, Attorney Cayosa.
Thank
After
you.
the break, we step outside the profession. What these cases mean for the public, for trust in the courts, and for every Filipino who follows a lawyer online. Stay right there. This is Abogado.
Welcome back. You're watching Abogado. Rules on lawyer discipline are written for the bar, but they land on the public, on the clients lawyers serve, and on the audiences lawyers reach. So we now turn to the citizen side of this story. Now, Attorney Cayoso, many Filipinos follow lawyers online as commentators, advocates, and influencers. What standards of conduct should the public reasonably expect from them?
Well, a higher level of conduct, not the ordinary person's level of conduct. If we go again by the rules on responsibility and accountability, and a long line of jurisprudence, it will still be propriety, it will still be honesty, it will still be integrity. So these are very general terms that a lawyer should be mindful of. We're not talking here about a crime. We're not talking here about civil liability. It's about ethics. So there's a lot more leeway. There are many gray areas. And that's why if you look at many cases, the jurisprudence varies, even the penalty. But what is definite is that the lawyer remains accountable one way or the other.
And Attorney Cayosa, from public posts, what about private messages? Usong-uso na kasi ngayon mga group chats.
Yes.
So you have group chats and then comments as well that you make. I suppose public din yung pag nag-comment ka on Facebook, but it depends on the settings of your friend.
Yes.
Kung naka-private setting yung friend mo, it's semi-public. But yeah, what standards should lawyers follow? Are they also held to a higher bar of behavior, even if it's just group chats? Like sa mga social, not just sa social media chats, but yung sa phone natin, yung iba-ibang messaging apps.
If we look at jurisprudence, the earlier codes of conduct and ethics of lawyers and the current one, the Code of Professional Responsibility and Accountability, it's the same. Whether you're doing it in your professional capacity or not as a lawyer, personal capacity, whether it is private or public, you are still held accountable. So, because it's the character of the lawyer that is being promoted or safeguarded here or demanded. So whether it is public or private, you're held accountable. Like, for example, love letters. It's just between you and your lover or your paramour. You'll be held accountable for that.
Parang may case na ganun, di ba?
Meron ba?
na-filean
Many
ng,
cases,
may
many cases.
na-filean ng
online.
administrative case because of that lawyer's relationship with another person while that lawyer is also married. Tapos parang naalala kong basahin yung decision kasama sa, I think it was the Iyala case, na nandun pati yung love letters.
Yes.
It was cited during the decision.
Many people would think, or even some lawyers would think, as long as it's not scandalous, it's kept private, the community doesn't know, then we're okay. But that's not the case. If you look at jurisprudence, even if it's very private, once it's brought up by the complainant, you're held accountable. Why is that? Because integrity must remain wherever you are, whenever. It doesn't. You don't maintain your integrity, your character for public consumption. For a lawyer, when you talk of ethics, it's your conduct, whether publicly or privately, and that's why we see a lot of cases. And then hats off din tayo sa maraming abogado. For example, with personal affairs, many lawyers would rather be disbarred rather than to turn their back to their real love. May mga ganyan. And we understand them, but at least for these lawyers, pinapanindigan
They
nila.
choose love over career.
Parang the monarchy, no? Di ba? He gave up the monarchy to marry a commoner, di ba, in England.
Okay,
Di ba?
oo nga, no?
But you see, what's happening there is like, hindi naman na nila pagbabawalan you stop that relationship. Because if they're willing to pay
The price.
for that relationship, so it's not really the conduct, it's how you, so, pwede. Pwede nilang gawin. And, many lawyers also, they say, okay, if this is the penalty for saying this, so be it, I'm okay. Like, for example, the young lawyer, Attorney Francis, he says, I accept the 1-year suspension, even if some people would find it very, very steep price for them. But he said, it is for my family. We speak out for my family. And maganda yung ganun. At least, we're not saying tama, but at least, abogado sa panindigan, kaysa yung iba na lantarang mali-mali ang sinasabi, kasinungalingan, o kaya wala na sa lugar, or pambabastos na, and they still try to wiggle out of it.
Now, if the lawyer naman, Attorney Cayosa, if the lawyer naman deletes the post, apologizes, or says it was made in anger, it was made out of passion, obfuscation, and how much weight should that kind of a defense carry?
But it carries weight to the extent that it will mitigate the penalty. Because then again, as I explained, yung integrity, it's supposed to remain there whatever the circumstances are. So, and the other one also is, yung anger or passion or even a wrong does not justify unethical conduct. The conduct expected of a lawyer is whatever happens, the word turns upside down, maintain your integrity. You maintain the respect for the administration of justice, you maintain the respect for the profession. Ang taas nga, mas mataas nga ang standard natin kaysa mga pari in that sense.
Higher than a priest?
Than a priest. We're the only profession.
I feel like a cardinal right now.
It depends. It depends kung sinusunod mo, partner.
Not in all aspects.
Not
but
in all aspects.
We are the only
I didn't even know
profession
that.
that really police our ranks, and it's done publicly. I mean,
Oo
eventually.
nga,
yeah.
that's
So,
true. Kasi it gets publicized.
Yes,
Kung ano
and
yung
no other
sanction.
profession is as active as we are in calling out our fellow lawyers. Yung iba, they don't even want to testify against their fellow professional. Abogado, minsan complainant, abogado din. O yung complainant, may abogado eh. So to me, that's a plus factor for our profession.
Yeah.
Na we should carry that as a badge of honor na kami, mga abogado, whatever the world will call us, at least kami, we hold to account our fellow lawyers.
And on that note, because you mentioned among other professions, ayaw mag-testify against their fellow
Yes.
nakasama sa profession like doctors. Alam ko mahirap magharap na expert witness sa doctors
Dito sa
because they,
Pilipinas,
they
yeah.
don't want to testify against
Yeah.
other doctors. But mabalik tayo sa mga abogado, when it comes to malpractice, mali-mali yung advice, maraming lawyers ngayon napaka-active sa social media. Pag merong current issue, magpo-post sila na mahaba about their opinion on that. Pero may iba naman, minsan mali-mali. Can they be penalized for that? Can people complain about them and then have them sanctioned for posting something that's legally wrong?
Well, they can. Of course, the usual defense is part of freedom of expression. You cannot curtail my right to express myself. Or they will say, Mr. President, opinion lang naman yan eh. I can be wrong, like any other lawyer. No? But aside from propriety, we also have provision against dishonesty and competence. When you cite a law or jurisprudence, make sure you cite the whole thing. Hindi lang yung kasi
Cherry picking,
You could do that perhaps as a counsel for one or the other party. That's understandable. But when you're trying to explain the law, at ipagpipilitan mo yun, tapos obviously, hindi na yun eh. Hindi na totoo yun eh. So you might be held accountable for intellectual dishonesty. And the honesty required of us is honesty in general. So that's one. The other one, of course, is competence. Fair and square. When you cite jurisprudence or a law and any rule, pag-aralan mong mabuti, hindi lang yung unang naisip mo, yun na yun. You have to be a responsible lawyer. So ito yung interplay na yung freedom of expression versus your ethical responsibility and professional responsibility as a lawyer.
No, because disciplinary cases are generally, as we mentioned earlier, these are generally confidential in nature, especially during the time that it's pending. Now, how can the system balance the lawyer's rights with the public's interest to ensure that there is transparency?
Well, the transparency comes with respect to the complainant, the private
Yes.
complainants. They're involved they know what's happening. The records are open to them, whether that's being investigated by the IBP or by the Supreme Court. And when a judgment is issued, mababasa nila lahat yon. And it's the duty of the Supreme Court to lay out what are the facts, what are the law,
Yes.
what's the jurisprudence. So at least that's assured of the lawyer. So, but why is it also confidential? Because it will be unfair for the lawyer to be prejudged. And sometimes, we find this very painful for the lawyers because, as I said, 80%, statistically, are really harassment cases. What happens? The lawyer cannot talk about it, but sometimes the clients, they just say, I filed the case against that lawyer. Alam mo naman kung minsan sa ating lipunan, nakasuhan ka na lang, presume guilty ka na eh. Walang ganun.
And mahirap for lawyers because you depend on your clients for
Yes.
your income, right? So
Yes.
kung masiraan ka ng reputation, the impact on your career would have financial consequences as well.
Yes, at hindi lang yan. And that's why our call always is, kung merong mga kaso, it should be resolved as soon as possible. Maabot ng siyam-siyam eh.
So normally ba, Attorney Cayosa, how long do these cases take before they are resolved?
Like, yung full-blown all the way out to Supreme Court, from 5 years to 10 years.
Ay, matagal pala.
There are
That's
even
hanging
some
on your head,
instances-
no?
Well, these are exceptional, but just to drive home the point, during our term, we are about to resolve it already, and then sandali lang, patay na yung tao. So buti na lang, somebody from that region said, mukhang patay na yung abogado na yan. So, you know, it's not just the fault of the Supreme Court. Also, IBP, sometimes the parties, they dribble it. Kasi nga kung harassment case yan, gusto na mas matagal. So if you cut it naman abruptly, sasabihin nila, walang due process, you didn't give us enough time. So these are all, but whatever the reasons may be, the fact is, masyadong matagal. So kawawa naman the respondent. At kawawa rin yung complainant kung sakasakaling meritorious. Because nga, the purpose of holding people to account, nawawala na kung masyadong matagal, nagkakalimutan na eh.
And in the meantime, if you say you have really a notorious lawyer, in the meantime, they get to practice their profession. Nag-iingay sila, lalo na if it's a type of lawyer na, yun nga, irresponsible, magsalita publicly.
And not only that, simply because they can dribble it, they keep on doing the same thing.
Yes.
Yeah.
So yun ang shortfalls nung too long a process. So we understand that the Supreme Court is very busy with more important cases, but you know, if you take on this responsibility, and this is your responsibility, including the IBP, bilis-bilisan naman natin because delay damages everyone.
Thank you so much, Attorney Cayosa. One more segment to go. When we return, we ask what should change and what exactly should stay as it is. This is Abogado.
Welcome back. You're still watching Abogado. Tonight, we've tested the boundary between a lawyer's speech and misconduct, examined the court's power to act on its own, and heard what these cases mean for the public.
Now, the forward-looking questions. Attorney Cayosa, let's close this out. So, should the court adopt written criteria for initiating disciplinary proceedings motu proprio, or is case-by-case discretion really the standard that should be followed?
I think it's enough that they have that power to investigate motu proprio, because if you make it too procedural or too strict, then you know Supreme Court might be compelled to tackle so many smaller cases that would unduly clog their dockets. As it is, hirap na sila dun sa mga malalaking kaso. So maari siguro yung sa IBP, because IBP also has that power. But the problem with IBP is that the members of the board only serve for 2 years. So hindi yung continuance, hindi ganon. Plus, you know, our officers are elected. So yung political considerations, baka at least ang Supreme Court yan until they retire. So those are the pitfalls dyan. So I think mas maganda na we give them that discretion. Ang siguro lang kinakailangan, yung an improvement would be the more notorious it is, the more public, because it's the public interest, the public good that we are safeguarding. The more public it is, the higher your position in the profession or in government or in industry, the higher level. So mas may compelling reason sana sa ganun. Because if we wait for complainants usually, they don't complain against powerful people, against popular people, kasi dehado na sila. So that's where I think the motu proprio power of the Supreme Court should come in for the public good.
Yeah, that's a good point. Kasi takot
Exactly.
ka pagka powerful, pagsikat. So that's when the Supreme Court should really step
Yes.
in and
Not against
initiate.
anybody, but for the public good, to maintain the
Correct.
ethical standard that is required and desired of lawyers and administrators of justice.
And like Attorney Cayosa said, dapat bilisan yung
Yes.
pag-decide.
Bilis-bilisan. At saka, wag na yung marinig natin na sana all. Diba? yung hindi selective. So, internally siguro, they would do that, or jurisprudence. They don't need to put that in the rule if they feel unduly hampered with that. But that's very important, especially nowadays. Yung social media, mabilis na yan eh. So, na-overtake. So, the damage is done, it remains there, it is not corrected simply because we're so passive and we're waiting for somebody to complain.
Dapat siguro baka magkaroon ng task force on this ang Supreme Court because the justices
That's
are
true.
very busy. Ang dami nilang kaso na nahawakan,
Dockets
no?
are so full,
Yeah.
as we know.
Yeah.
And also, ang victim lang dito, hindi not only the public, not only the aggrieved party, the image of the justice, the courts themselves.
Exactly.
So they have to protect that. They have to protect their officers of the court na hindi mabahiran lahat ng skandalo kung hindi natutugunan ito kahit walang complainant.
Thank you so much, Attorney Cayosa, for walking us through the standards that govern what lawyers may say and the price of saying too much.
Tonight reminds us that a law license is a privilege carrying duties that never clocked out. In the courtroom, in the airwaves, and on every screen or platform.
The challenge is balance, holding lawyers to a higher standard of speech without hushing the voices that keep power in check. This is
Abogado.
Good
Good night.
night.